Hi, and thanks everyone for joining us today for today's webinar on the NDIS Housing Supports and Appeals. My name is Kate Scanlon, and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd like to firstly acknowledge the traditional owners of the land on which we are holding today's webinar in Meanjin, Brisbane. They are the Turrbal and Yagara people. I wish to pay respects to their elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay respects to traditional owners throughout the country and extend a warm welcome to any First Nations people listening today. Today, we're pleased to welcome Ridmi and Louise from Queensland Advocacy for Inclusion, who'll be talking to us about the NDIS and the housing supports. The National Disability Insurance Scheme was introduced with an exciting new range of home and living options for people using the scheme. Today we'll explore the options available with a focus on the legislative framework, documents required by the NDIS to secure funding for specialist disability accommodation, appeals of NDIS housing support decisions will also be covered during the presentation today. I'll let our presenters tell you a bit more about themselves when I hand over in a moment. But before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have the recording available for download for you later in the week. The PowerPoints and materials will also be emailed out after the presentation today. We encourage you to ask questions, so simply type your questions in the question box on the control panel and we'll read your questions out towards the end of the presentation. So we'll hold them all until the end, but feel free to type them as you think of them throughout the webinar today. So I'll hand over to our presenters who will tell you a little bit more about the topic of themselves.
Good morning, everyone. I begin today by acknowledging the Yagara and Turrbal people, traditional custodians of the land from which I come to you today, and pay my respects to their elders past and present. I extend that respect to all the traditional custodians of the land which our attendees are on, and any Aboriginal and Torres Strait Islander people here today. We acknowledge the stories, traditions, and living cultures of Aboriginal and Torres Strait Islander peoples on this land and commit to building a brighter future together. Before we begin our presentation today, we would like to get some responses to a poll so we have a better understanding of our attendees. Kate, can we have the polls, please?
Okay, so it looks like we've almost had everyone respond to the first poll, which is, have you ever assisted someone with an NDIS plan on a separate legal issue? So I'm just going to give a little bit more time for people to respond. And now I'm just going to close the poll.
Yeah, so I can see that 45% of our attendees have responded yes. You will find some parts of this presentation familiar depending on the supports that were included in your client's plan. The second one, please.
Okay, and I can see we have almost everyone has responded to this one as well.
Okay.
I can see quite a few
So,
people. I'll just close it and show you the results.
yeah, so we can see the highest number of participants has responded to yes, housing. You will be able to relate how NDIS supports interact with housing settings such as Department of Housing and Rentals during this presentation. The third one, please.
I can see it appears that we might have had some of the words cut off there, perhaps on the second or third answer. Readme, would you be able to, if there's any clarification that's needed, provide a little bit more?
The third is, have you been approached by someone seeking help in relation to specialist disability accommodation supports? A, no. B, yes, but I couldn't help them. C, yes, and I referred them to LAQ and or an NDIS appeals advocacy organization. D is yes, I provided them with advice with reference to the NDIS Act and relevant rules. E, yes, I represented them in their NDIS internal review or external review proceedings.
Fantastic, thank you. And it looks like most people have responded to that one as well. So I'll just close it and I'll share the results.
Okay. Can we have the fourth one, please, Kate?
All right, I'll just give it a couple more seconds and then I'll close that last poll. I can see we've got about 3/4 of people so far have responded. So I believe those are all the polls with me. Do you need to see any of the results again to discuss with the audience, or are you happy to continue on with the content from here?
I think we'll continue given the time is limited, Kate. So we are happy to proceed with the rest of the presentation.
Okay.
And so particularly in relation to poll number 4, we can see that 50% of our attendees have responded no. We will be discussing the basics of the internal review and the external review process in this presentation. And if you ever come across a client that needs assistance with those processes, you will be able to provide them basic direction as to what has to be done and refer them to an appropriate organization. Okay, so let's move on to the overview for today. By the end of the presentation, you will have an understanding of the different types of home and living supports that can be funded by the NDIS, general criteria for accessing home and living supports through the NDIS, specialist disability accommodation referred to as SDA, with a focus on the eligibility criteria, design categories, building types, and additional criteria applicable on SDA matters. You will also develop an understanding on how to preserve review rights of a client who is not satisfied with home and living decision, and where to refer them if they need more supports than what you can provide. Different types of home and living supports can be included in a participant's plan. Today's focus will be on SDA, supports that assist the participant to live in their home, such as home modifications and support worker time. We will also be speaking about short-term accommodation and medium-term accommodation. The National Disability Insurance Scheme Act of 2013, also referred to as the NDIS Act, sets out the foundation for receiving supports through the NDIS. Section 34 of the Act outlines the criteria that a support should meet in order for it to be funded under the scheme. This criteria contains 6 requirements, and it is commonly known as the reasonable and necessary criteria. For support to be funded by the NDIS, it has to assist the participant pursue their goals and aspirations. The support sought must facilitate the participant's social and economic participation. The support must represent value for money. The support has to be effective and beneficial. And the support must not be a support that is reasonably expected to be provided by families, carers, and informal networks. Also, the support has to be a support that is most appropriately funded by the NDIS and not a support that is often funded by other systems such as health or housing, for example. Supports for participant rules provides details of key terms in the reasonable and necessary supports criteria in the NDIS Act. For example, they go into detail about what is value for money, what is reasonable to expect families and carers to provide. The rules also state about what supports the NDIS will not fund. For example, NDIS will not fund supports that poses a risk to the participant or others, supports that duplicates other supports in the NDIS plans, supports that are not related to the participant's disability, and supports that are considered as an everyday living cost. The rule relating to that which the NDI will not fund supports that is an everyday living cost is particularly related to our topic today. With the current housing crisis, we see the NDIA noting that the cost of paying for accommodation or a house is an everyday living cost in their decisions to refuse housing supports requested through the NDIS. Being an NDIS participant solely is not enough to secure housing supports through the NDIS. In addition to the NDIS, the participant support rules. There are also particular rules that are applicable to specialist disability accommodation, and Louise will go into detail about these rules. Then on top of that, there is also the NDIS operational guidelines, which is not considered law and are only applicable as far as they are consistent. They are applicable as far as they are not inconsistent with the law. Then when we talk about the external review process, we will also be talking about the Administrative Appeals Tribunal Act of 1975. Now I'll hand over to Louise to talk about specialist disability accommodation.
Thank you, Ridmi. Hi, everyone. So I'm going to be talking about specialist disability housing. The introduction of the NDIS opened up a brand new range of housing for people on the scheme who require a very specific property type to support their physical or other disability needs. Specialist disability housing is for people on the scheme who have an extreme functional impairment or very high needs. And this is really only for a small proportion of people on the scheme. To get SDA built into a plan, a home and living assessment and report is typically undertaken by an occupational therapist, and they'll consider all different home and living options. The OT may recommend that SDA is appropriate for the participant, and the home and living report will then be provided to the agency. If the agency agrees, the SDA funding will be then built into the participant's plan. The agency will pay an annual amount to the SDA provider of the participant's choosing. And it's just important to note the SDA is for the accommodation only, not for any support worker time. So there are 4 different categories of SDA design that many of you are probably familiar with. There's a specific SDA design standard that's a detailed set of requirements for all new SDA to be built. So the developers building these properties have to adhere to those design standards. And SDA dwellings must also, of course, comply with the Australian National Construction Code. The 4 design categories of SDA are improved livability, and that's a category of housing designed to create better physical access. It has more features for people with sensory, intellectual or cognitive impairments. For example, a person living with a vision impairment may need walls and floors that are easy to see, or they may require no or very few stairs. And then we have the next level up from that in terms of accessibility. So that's fully accessible housing with a high level of physical access features for people who have lots of physical challenges. For example, they use a manual or powered wheelchair at home, or they can't use steps. And then we have high physical support category, and that's housing for people that require a very high level of physical access, or for people who have very high needs of support. For example, people who require a ceiling hoist. Robust is another category that's a bit different to the above categories, and that's housing that is very strong and durable and reduces the need for repairs and maintenance. And that type of design category is designed to suit people who may need help managing complex and challenging behaviours. So what do you need to demonstrate to show eligibility or gain access to SDA and have that built into your NDIS plan? there are some key qualification requirements, and these are contained in the SDA rules. And to be eligible, the agency needs to be satisfied that the participant has an extreme functional impairment, and that's under section 12 of the rules, or has very high support needs under section 13. And in addition to either of those, the participant meets the NDIS needs requirement. And this is quite a high bar, so meeting either the extreme functional impairment or the very high support needs is difficult, and that's in line with the relatively low percentage of participants, just 3.8% of participants with SDA in their plan. So in regards to extreme functional impairment, under section 12, the impairment needs to result in extremely reduced functional capacity associated with just one of these areas. So it can be mobility, self-care, or self-management. And when we're talking about extreme, we're talking about an impairment of the highest degree. So the case of Charrington has noted that it's beyond a substantial impairment to functional capacity. It is an impairment of the highest degree. So if a person doesn't meet that extreme functional impairment criteria, they may still meet this criteria of very high support needs. And if they can demonstrate that they have very high support needs and need support for a very large proportion of the day, they can demonstrate SDA eligibility. So this may occur if they can't demonstrate an extreme functional impairment in one of the three areas on the previous slide, but they can demonstrate that they have very high support needs day and night. So once either section 12 or 13 are satisfied, the participant must demonstrate that they meet Rule 14 of the SDA rules, and that requires consideration of how the SDA will assist the participant and be effective and beneficial for the participant, as well as being value for money compared to other supports alone. And they need to meet all the criteria in Rule 14 of the SDA rules. Just going to talk to you now about an important case example. This is the case of Charrington and the NDIS. So Miss Charrington was a 53-year-old woman at the time of this matter, and she lived with a visual impairment, anxiety, depression, and attention deficit disorder. Miss Charrington lived in a ground floor apartment, and that was provided through the Brisbane Affordable Housing Company. And the tribunal went through the SDA criteria in the rules, as I just went through with you before, and on the extreme functional impairment, they found that the evidence showed that Miss Charrington was able to spend entire days in her home without support, regularly attend the local shops and other appointments independently. She could carry out many activities of self-care on her own, although she would benefit from additional support. And she was largely independent in managing her own affairs. So the tribunal found that she did not meet the extreme functional impairment criteria for SDA. On the need for person-to-person supports, the tribunal found that the Miss Charrington's need for person-to-person supports were not very high, as she didn't have a need for immediately available or constant supports for a significant part of each day, and the evidence showed that she could and often did spend entire days without support. The tribunal also then went on to consider the needs requirement, and what they found was that Miss Charrington had access to funding for a home and home modifications assessment, but that assessment had not yet taken place, and they found that an evidential deficit existed because they weren't able to compare life with and without SDA, because Miss Charrington had not yet had the opportunity to live with other funded supports. And it wasn't possible to compare the real meaning of value for money of the supports of SDA with other funded supports, including the cost of home modifications. That just weren't known at the time. So the tribunal found Miss Charrington did not meet the criteria, and the main reason was that she didn't, that the evidence didn't adequately address that value for money criterion in section 14, because she had a home that could be modified and had not yet been modified. Just to also note, and this goes back to what Ridney was saying, the tribunal found that the issues that Miss Charrington had faced in terms of difficulties in finding a home were not directly relevant, because the evidence before the tribunal and the applicant's search for a new home and the difficulties she may face on a limited budget and in a tight rental market do not address the directly relevant statutory criteria for access to funding for SDA. And the applicant didn't meet the criteria and the decision was affirmed. Now on to types of SDA dwellings. So once a person is found eligible for SDA, the agency will then go on to decide what type of dwelling should be built into a participant's plan, taking into account the participant's evidence. So there are three main sort of categories or types of dwellings. So there's the apartment category, which has 1 to 2 bedrooms, the villa, duplex, townhouse category of funding, and they all have the same level of funding, and that has 1 to 3 bedrooms, and house funding, which generally has 2 to 4 bedrooms, and these are all in the SDA price guide, the actual levels of funding. So in regard to how the accommodation is set up, the agency can sometimes decide that a participant should share accommodation with another participant, or they sometimes can fund sole occupancy. And it is also possible for participants to live with family or friends, and a reasonable rent contribution will apply to those adults who are not NDIS participants or don't have SDA in their plans. So how does the agency make these decisions? Well, the agency takes a number of matters into consideration when deciding what building type, including number of bedrooms, should be built into the participant's plan. The matters to be considered are outlined in section 16 of the SDA rules, and they take into account preference, the participant's preference, their needs for the SDA, the value for money of the SDA, the facilitation of social and economic participation that will come about if they move into the SDA of that particular building type, and the facilitation of support. So how will that particular building type facilitate their informal and other supports? And so we do this, see disputes about building type come up quite regularly. So some common disputes that we see are the agency's decision to not provide the SDA resident with sole occupancy. And we also see the agency's decision to not provide the resident with the number of bedrooms sought come up as a common dispute. So sometimes an additional bedroom is sought for a carer or to store disability-related equipment, and the agency can refuse this. Just going to pass on back to my colleague Ridme to talk to you about Kennedy and a QAI matter.
In Kennedy and NDIA, Mr. Kennedy was a participant suffering from functional quadriplegia, PTSD, anxiety, and depression. During the course of his tribunal proceedings, the tribunal conceded and agreed that he should be funded for a one-resident, one-bedroom high physical support SDA. He sought a second bedroom in his SDA to parent his 2 young children, set a home office to become a mentor for the Aboriginal and Torres Strait Islander community, store his disability-related pieces of equipment, and to provide accommodation for his carers. The tribunal considered Mr. Kennedy's preference, how the requested SDA will assist him to pursue his goals, increase his social and community participation, as well as how it would assist him to maintain his family unit, and decided that one resident, 2-bedroom high physical support SDA was a reasonable support for him, and substituted the original decision. Recently, QAI assisted a participant in her mid-30s with a rare neurodegenerative hereditary condition in an SDA matter. She was a single mother and had a teenage daughter. She was funded for a 2-resident, 2-bedroom SDA. In our submissions, we were able to articulate that a sole occupancy 2-bedroom SDA was her preference, while the same allowed her to maintain and strengthen her informal relationships, particularly in relation to her parenting, and that it was a 2-bedroom sole occupancy was suitable for her support needs and allowed her to maintain her employment. We also submitted details of risks posed by a shared living arrangement to our client and her daughter in our submissions as to why she should be funded for a sole occupancy. The agency agreed to fund a sole occupant villa townhouse type SDA for her. NDIS home and living supports can also include supports that allow the participant to live in their own home, such as support worker time. At the beginning of this presentation, we spoke about the reasonable and necessary criteria when finding the quantum of support worker time and the times, and when deciding the times that a support worker should be funded for. The agency takes into consideration the reasonable and necessary criteria. Some of the evidence that can assist to secure support worker funding are functional capacity assessments, statements of lived experience, carer statements, and also timetables of supports provided to the participant from paid and unpaid carers. QAI assisted a 58-year-old participant who had suffered multiple strokes that resulted in an acquired brain injury. He was living in his own home, but did not have sufficient support worker time. In his plan, he was funded for support worker time to share with another participant. So, to make sure that he had 24/7 supports, he was required to move out of his home. His home did not have room for another participant to live there with him. Our client's history of strokes was related to times he was stressing about accommodation. There was also evidence from his support workers about the support workers finding our client with accidents repeatedly when they commenced shifts after periods of time that our client was left unsupported. We provided detailed functional capacity assessment reports, multiple carer statements, supports timetables, and incident reports, and was able to secure 24/7 one-on-one supports for this particular client, which in turn enabled him to remain living in his home. Now, I will pass on to Louise to speak about home modifications.
Thank you. So the NDIA can fund home modifications, and they commonly do. All home modifications must meet Section 34(1) criteria, as Rhythmi went through to get approved. For newly purchased homes, after the person becomes an NDIS participant, there needs to be an element of reasonableness in the request to the agency. And for example, if a participant purchases an older double-storey home and then requests large-scale modifications to the upper level, which they want to use as the main living and sleeping area, or requests a lift to the top level, the agency may question the decision to purchase that particular home or why the downstairs level can't be used as the main living space. The agency categorises home modifications as minor home modifications, and those are modifications that cost up to $20,000. Or they categorise them as complex home modifications, and those are larger home modifications costing over $20,000 that require a few change or involve a few changes to the participant's home. For example, combining a bathroom and toilet to give more room to use a hoist or a shower chair. For complex home modifications, an experienced or qualified home assessor, and that's usually a qualified occupational therapist, must assess the needs at home and certify the effectiveness of the modification to meet the participant's goals and likely future needs. On the slide here, we have the number of sort of some examples of different home modifications that the agency can fund. So we've got bathroom home modifications there, kitchen home modifications, internal and external chair lifts, exterior ramps and pathways, widening internal doorway openings is a common one, and air conditioning. I'm just going to talk through a case that it was in relation to a request for a lift, an elevator within a home, and that's the case of LZMX and the NDIA. So LZMX was a matter that involved a person living with a double leg amputation, and the application related to the question of reasonable and necessary supports in their plan for building and renovation costs to a property. And that property was purchased by a company of which the applicant's daughter and her partner were directors, and into which the applicant and his wife intended to move and occupy as tenants in a granny flat agreement. In the lead up to the hearing, the majority of the building issues had been resolved between the parties, but the remaining issue was whether a lift installed in the premises to provide access to the first floor was a reasonable and necessary support. And just to give you an idea of the timeline, in early 2017, the applicant and his wife asked his daughter to consider purchasing the dual purpose property that would accommodate her psychology practice. And then in July 2017, the applicant's daughter purchased that 2-story property, and then went on to set up the business on the ground floor. And the applicant and his wife went on to live upstairs. The quotes were then received for a lift, and the family went ahead and ordered the lift before it was approved by the agency. The agency did not agree to provide that funding for a lift. An OT at the hearing, an OT provided evidence to the effect that alternatives to the lift, such as a chair lift or a platform lift stair, were not appropriate to the applicant's needs. However, no comprehensive assessment of alternatives was undertaken. So at the time of the hearing, property renovations were nearing completion and a lift was already in place. And the agency submitted at the hearing that there were two main reasons the lift was contentious, and that was that a decision had been made between the applicant and his family well before funding was sought to install the lift, and the applicant and his family were intending to complete work, including the lift and financing it, regardless of the outcome of the NDIA appeal. So the agency submitted that this was a cost that fitted squarely in section 34(1)(e) of the reasonable and necessary criteria in regard to what it was reasonably expected of families to provide. And the tribunal affirmed the decision under review to not fund the lift. The tribunal found that the family's decision to have the applicant with his and his wife live on the top level of the home and his daughter's business downstairs was a choice made by the family, driven by a lifestyle decision. So that was the case of LZMX. I'm now going to talk to you about an air conditioning case, and that's the case of Mackenzie and the NDIA. And in this case, the applicant sought funding for the replacement of his ducted air conditioning, which he had installed in his home when it was originally built 18 years ago, and the system was out of date and it was no longer effective. Mackenzie gave evidence, he lived with MS, and he gave evidence about his MS symptoms worsening and higher temperatures, and expert witnesses confirmed that the people with MS experience a temporary worsening of symptoms when their core body temperature rises. The NDIA had offered to fund the installation of 2 reverse cycle split systems in Mackenzie's home, but maintained that the replacement of the ducted system was something Mackenzie and his wife ought to pay for, as it was an everyday household item, particularly within homes in Queensland. The tribunal determined the matter in Mackenzie's favour and concluded that a constant temperature within the home via a replacement ducted system was not an everyday expense and was reasonable and necessary for Mr. Mackenzie as it related to his support needs. So I'm just going to also talk to you about different home environments and their interaction with the NDIS. So in regard to Department of Housing properties, they can be modified using NDIS funds. So we have supported persons who live in Department of Housing properties with this, and we've also supported persons who live in Department of Housing properties in SDA disputes, so where they've been seeking to move out of the Department of Housing property into SDA, and assisted them to actually get into an SDA and be found eligible for SDA. We also have we also see interactions with renters who are renting properties, and they can also be supported by the NDIS to have modifications done to the property they are living in. However, that can be, of course, complicated by the landlord consenting, and in getting that approved by the agency is likely to take things like the lease period into account and other factors. In regard to private home ownership, we have assisted private homeowners in disputes with the agency about home modifications. The agency will look closely at any alternatives to the requested modifications. So it's common in these matters for the agency to consider whether the home can be used in an alternative way to provide an appropriate outcome. And just an important note on aged care. So it's just important for people to know that if a person enters aged care before the age of 65 as an NDIS participant, they'll maintain their NDIS participant status. However, if they enter aged care after the age of 65 and are an NDIS participant, they'll cease to become an NDIS participant under Section 29(1)(b) of the NDIS Act. So this is important to note, because sometimes older people can feel pressured that they have to go into residential aged care. However, if they're an NDIS participant, they are entitled to supports through their life and can possibly remain supported at home. Just going to pass you back to Ricky now.
So now I'm going to talk about short-term accommodation, which is also known as respite. This is a support given when a participant needs to live away from their home for a short period of time, less than 14 days, for various reasons, such as to try new things or to maintain current living arrangements of the participant by giving regular carers a break. Short-term accommodation covers the cost of care of participants outside of their home. This usually can be funded for up to 28 days per year to use flexibly. For example, a participant might want to use it in blocks of 14 days, 2 blocks of 14 days, or in smaller blocks throughout the year. Funding is usually for a group price unless there is evidence that the participant needs to be supported individually because of their disability. Recently, we assisted a 12-year-old First Nations boy who was living with his grandmother. The grandmother was having serious health issues. Providing a break to the grandmother, who was his only reliable informal carer, was recognized by the NDIA, and he was given 28 days of short-term accommodation, which consisted of 20 weekdays, 4 Saturdays and 4 Sundays, among other things in his NDIS plan. Medium-term accommodation is a support that may be included in a plan when the participant has confirmed long-term housing arrangement, but can't move or live there because the disability-related supports are not ready in their long-term housing arrangement. The term medium-term accommodation is funded for is up to 90 days and is usually a one-off support that is linked to another support in their plan. For example, a participant who has secured SDA, specialist disability accommodation, can be funded for a medium-term accommodation until the previous tenant in the accommodation vacates the property and the property is ready for the participant to move in. Some examples to show that there is a long-term housing, some evidence that the participant can submit to show that they have a long-term housing solution can be builder's quote that states the likely time period that's needed for the modifications to be completed, tenancy agreement offers, and other documents, which are usually functional capacity assessment, which shows that the participant meets the reasonable and necessary criteria to receive medium-term accommodation. QAI assisted a participant in her 60s with cerebral palsy through her NDIS appeal at the Administrative Appeals Tribunal. She was requesting for bedroom and bathroom modifications at the tribunal. So there was evidence from the builders which showed that the modifications process would take at least 21 days. So we included 24 days of medium-term accommodation into her requested supports at the Administrative Appeals Tribunal. That way she had a suitable place to stay until the home modifications were being carried out in her house. In the next part of this presentation, we will be focusing on what a person must do if they are not satisfied with home and living support decision. So you are aware of how you can assist such clients and know where you could refer those clients for assistance beyond what you can give. The review process consists of 2 stages, internal review and external review. There are applicable time limits, so it is important to act quickly. The initial step of the review process is externally reviewing the decision at the NDIA level. These reviews are also known as Section 100 reviews and review of reviewable decisions. These applications must be lodged within 3 months of receiving the notice of the original decision. The application can be initiated in person, via phone or email. We recommend lodging internal review applications via email by lodging the approved form, as it is easier to keep record of an application this way. It is good to include the participant's number and the fact that it is an internal review application in the subject line of the email. The application should also clearly state the outcome being sought, and any new reports obtained since the date of the original decision should be attached to the application. And also we recommend that pointing to specific paragraphs, statements, and recommendations that supports the decision being sought can be helpful in getting the outcome they're seeking. If a participant is not satisfied with the internal review decision, they have to lodge an external review application at the Administrative Appeals Tribunal within 28 days from receipt of the internal review decision. It is important to note the short timeline here and that action has to be taken quickly. A copy of the original decision has to be attached with the external review application. If there are particular circumstances that makes the action on the application being done on an urgent basis, such as when there are circumstances that there is significant risk posed to the participant, a statement or a letter outlining those risks also should be provided with the application. A participant may also forward any new information they have at this stage. However, it is important to note that it is they should not stress about gathering new evidence at this stage, as there will be an opportunity to provide new evidence throughout the tribunal proceedings. When an external review application is lodged at the tribunal will acknowledge the receipt of the application and assign a case number for the matter. The applicant will also receive a bundle of documents called the T documents. The tribunal will also inform the participant of the date of the first case conference. The lawyers representing the NDIA will be in touch with the participant before the first case conference and also will forward a document called the Statement of Issues, which outlines the NDIA's position in relation to the supports being sought. From our experience, matters at the tribunal can take up to 12 months. The process usually involves a series of case conferences which discuss the issues, provides opportunity for the applicant to submit any additional evidence. In the process of the tribunal proceedings, the issues are discussed and they are narrowed to a point where an agreement is reached or a conciliation is held to try and resolve any final issues, or a hearing is conducted so a tribunal member can make a decision on the matter. However, from our experience, only a small number of appeals at the AAT proceeds all the way to a hearing. Now, in the next slide, we have names of organizations that are specialized in assisting with NDIS appeals. Contact details of these organizations can be found on the Department of Social Services website. Whether these organizations are able to assist may depend on where the participant lives. That concludes our presentation, and thank you for joining us today. If you have any questions, we are happy to address them. Thank you.
Thank you so much for sharing all of this information. It's been fantastic. I might just see if we have many people sending questions through. I'm mindful of the time. So perhaps if you have any questions, you could either send them through now in the questions box that should be on the side of your GoToWebinar control panel, or you can email me them directly. I'm mindful that we're almost at 11 o'clock, so perhaps what I might do is I can send any questions that we receive to our presenters, and then I'll send out an update later on when I also send out the slides for the presentation. Thank you so much, Louise and Ridmi, for your time and expertise. Before people go today, I'd like to just remind everyone to complete the feedback survey that will pop up on your screen once we close the webinar. Your feedback helps us to continually improve our webinar program. We hope to see you next time at our next CLCQ webinar, but bye for now. Thank you.